Welcome to We Learn Virtual Learning Network. This is session number 10, Legislature. Topics which we are going to cover in this session are Indian Legislature Historical Background, Union Legislature, the Presiding Officers, Legislative Procedures, Parliamentary Privileges, Parliamentary devices to control the executives, state legislature, and decline of legislature. Coming towards the very first topic, that is Indian legislature historical background. Indian Parliament did not emerge overnight. It evolved gradually during the British rule, particularly since 1858, when the British Crown assumed sovereignty over India from the East Indian Company. The Indian Council Act of 1861 introduced little bit of popular element as it included some additional non-official members of the Executive Council and allowed them to participate in the transaction of legislative business. Indian Council Act of 1892 made two important improvements. First, non-official members of the Indian Legislative Councils were henceforth to be nominated by the Bengal Chamber of Commerce and the provincial legislative councils, while the non-official members of the provincial councils were to be nominated by certain local bodies such as universities, district boards, municipalities. Secondly, the councils were empowered to discuss the budget and address questions to the executives. Indian Council Act of 1909 based on morally Minto reforms for the first time introduced both representative as well as popular features. At the center, election was introduced in the Legislative Council through the officials still retained the majority. The next phase of legislative reform emerged out of the Government of India Act 1919 brought further legislative reforms in the form of responsible government in the provinces. At the center, the legislature was made bicameral and elected majority was introduced in both the houses. The Government of India Act of 1935 came into being after several parleys between Indian national leaders and Britain. The Government of India Act of 1935 came into being after several parleys between Indian national leaders and Britain. The legislature of each dominion was to have full legislative sovereignty. The power of the legislature of the domination were exercisable without any limitation whatsoever by the Constituent Assembly formed in 1946. Next topic is Union Legislature. Under the provision of Article 79, the Parliament of India consists of President and the two houses. The lower house or the Lok Sabha, that is the House of the People, and the upper house or Rajya Sabha, Council of States. The Lok Sabha is subject to dissolution. The Rajya Sabha is a permanent chamber which cannot be dissolved. The office of the President also never remains vacant. The President. The President of India performs certain important roles side by side of the parliament. The president summons and prorogues the house for one session to another and has the power to dissolve the Lok Sabha. No bill passed by both the houses can become a law without the president's assent. The president also has the power to promulgate ordinances when both the houses are not in the session. The lower house or the House of People is popularly known as Lok Sabha. Its members are directly elected by the people. The maximum number of members to be elected, which was fixed by the Constitution, is 500. The distribution of seats among the states is based on the principle of territorial representation, which means each state is allotted seats on the basis of its population in proportion to the total population of the states. The election of Lok Sabha is conducted on the basis of adult franchise. Every adult who has attained 18 years of age is eligible to vote. The candidate who secures the largest number of votes get elected. The Constitution provides for an independent organization known as the Election Commission to conduct the elections. To be a member of Lok Sabha, a person should be an Indian citizen, must have completed 25 years of age and must possess all other qualifications that are prescribed by the law of the Parliament. Coming towards the Rajya Sabha. The Rajya Sabha or Council of State consists of not more than 250 members, of which 12 members are nominated by the President from amongst persons having special knowledge or practical experience in literature, science and arts and social services. Unlike Lok Sabha, Rajya Sabha adopt the method of indirect election. Rajya Sabha is a continuing chamber as it is a permanent body not subject to dissolution. Special powers of Rajya Sabha. First, under Article 249, the Rajya Sabha has the power to declare that in the national interest the Parliament should make laws with respect to a matter enumerated in the state list. If by a two-third majority, Rajya Sabha passes a resolution to its effect, the Union Parliament can make law for the whole or any part of the India for a period of 1 year. The second exclusive power of Rajya Sabha is with regards to the setting up of all India services. Next is presiding officers. Each House of Parliament has its own presiding officers. The Lok Sabha has a Speaker as its principal presiding officer and a Deputy Speaker to assist him and officiates as presiding officer is in his absence. The Rajya Sabha is decided over by the chairperson assisted by the deputy chairperson. Speaker. The position of the Speaker of Lok Sabha is more or less similar to the Speaker of the English House of Commons. The office of the Speaker is symbol of high dignity and authority. He acts as the guardian of the rights and privileges of the members. The Speaker is conferred with the member of powers to ensure an orderly and efficient conduct of the business of houses. Chairperson of Rajya Sabha. The Vice President is elected by the members of both the Houses of Parliament, assembled at a joint meeting in accordance with the system of proportional representation by means of single transferable vote, and the voting at such election is by secret ballot. The functions and duties of chairperson of the Rajya Sabha are the same as those of the Speaker of Lok Sabha. Next is the legislative procedure. The first stage of legislation is introduction of a bill which embodies the proposed law and is accompanied by the statement of objects and reasons. The induction of the bill is also called the first reading of the bill. There are two types of bill. A bill other than money or financial bill may be introduced in either house of the parliament and require passage in both the houses before it can be presented for the president's assistant. The two bills are ordinary bills and the money bills. In the second stage, there are four alternative courses. These are: after its introduction, a bill may be taken into consideration, may be referred to a select committee of the House, may be referred to the joint committee for both the houses, may be circulated for the purpose of soliciting public opinion. While the first three opinions are generally adopted in case of routine legislation, the last option is restored to only when the proposed legislation is likely to arouse public controversy and agitation. The day of these motion is carried out, the principle of the bills and its general provisions may be discussed. If the bill is taken into consideration, amendments to the bill and clause by clause consideration of the provision of the bill is undertaken. If the bill is referred to the select committee of the House, it considers the bill and submit its report to the House. Then the clause of the bill are open to consideration and amendments are admissible. In the third stage, the member in charge moves the bill he passes. At the third reading, the progress of the bill is quick, as normally only verbal or purely formal amendments are moved and discussion is very brief. Once all the amendments are deposited of, the bill is finally passed in the House where it was introduced. Therefore, it is transmitted to the other House for its consideration. When the bill comes up for considered by the other houses, it has to undergo all the stages as in the originating house. There are three options before the House. These are: it may finally pass the bill as sent by the originating House. It may reject the bill altogether or amend it and return to the originating House. It may not take any action on the bill, and if more than 6 months passes after the date of receipt of the bill, this means rejection. The originating House now considers the returned bill in the light of amendments. If it accepts these amendments, it sends a message to the other houses of the effect. If it does not accept these amendments, then the bill is returned to the other house with a message to that effect. In case both the houses do not come to an agreement, the President convenes a joint sitting of the two houses. A bill that is finally passed by both the houses is presented with the signature of the Speaker to the President for his assent. This is normally the last stage. If the President gives the assent, the bill becomes an act and is placed in the statute book. If the President withholds his assent, there is an end to the bill. Next is the money bills. Financial bills may be said to be any bill which relates to revenue and expenditure. A money bill cannot be introduced in Rajya Sabha. Once a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha. The Rajya Sabha cannot reject a money bill. It must, within a period of 14 days from the date of receipt of the bill, return the bill to the Lok Sabha, which may thereupon either accept or reject all or any of the recommendations. If the Lok Sabha accepts any of the recommendation, the money bill is deemed to have been passed by both houses. If a money bill passed by the Lok Sabha and transmitted to the Rajya Sabha for its recommendation is not returned to it within 14 days, it is deemed to have been passed by both the houses at the expiry of the said period in the original form. Next is the parliamentary privilege. There are two types of parliament privilege for the members of parliament: enumerated and unenumerated. The important privileges a member enjoy under the enumerated category are freedom of speech in each house of the parliament, immunity from proceedings in any court in respect of anything said or any vote cast. Immunity and liability in respect of publication or under the authority of either House of Parliament or of any report, paper, votes or proceedings. Freedom from arrest in civil cases for duration of the session for a period of 40 days before and after the session. Exemption from attending as a witness in the court. Next are the parliamentary devices to control the executives. The rules of procedure and conduct of business in Parliament provide that unless the presiding officer otherwise direct, every sitting begins with the question hour, which is available for asking and answering question. The real object of the member is asking the question is to point out shortcomings of the administration, to ascertain the thinking of the government in formulating its policy, and where the policy already exists in making suitable modifications in that policy. Members can, with the prior permission of the presiding officer, call the attention of the minister to any matter of public importance and request the minister to make a statement on the subject. The minister may either make a brief statement immediately on mass or may ask for time to make the statement at a later hour or date. The accountability of the executive to the parliament and the parliament right to oversee the scrutinize the way in which the executive functions are accepted as axiomatic. Among the important committee which scrutinize the government work particularly in the area of public finances. Two committees need special mention: Public Accounts Committee and Estimates Committee. Committees provide an ideal context for discussing controversial and sensitive matters in a non-partisan manner, away the glare of publicity. They provide a useful forum for the utilization of experience and ability that may otherwise remain untapped. They also constitute a valuable training ground for the future mistake and presiding officers. Next is the state legislature. The choice of unicameralism or bicameralism was left to the state, depending on how they weighed the functions of the second chamber compared to the cost involved in running it. Very few states have opted to have bicameral legislature consisting of the Legislative Assembly and the Legislative Council. The membership of Legislative Council shall not be more than 40, but not more than one-third of the total membership of the Assembly. The House is composed of party elected and partly nominated members. The position of the Council is inferior to that of the Assembly, so much so that it may well be considered as unnecessary. The very nature of composition of the Legislative Council makes its position weak, being partly elected or partly nominated and representing various interests. Its survival depends on the will of the Assembly, as the latter has the power to abolish the second chamber by passing a resolution. The Council of Ministers are responsible only to the Assembly and not to the Council. As regard any ordinary bill originating in the Assembly, the Council's person is very weak, for it can only delay its passage for a limited period. The legislative process in the State Assembly is similar to that of the Parliament, with one significant exception. Last topic is decline of legislature. Parliament is simply not able to devote its entire time to the details of the legislative measures. It could be at least lay down broad policy and leave the rest to be taken up by the executives. All bills contain a clause empowering the government to frame necessary regulations and bylaws. The ever-changing political and moral conditions in India are also responsible for the decline of prestige of Parliament. So that's all for the session. Following are the questions which are based on this session. These are: what is a question hour, and bring out the significance of adjournment motion. Thank you. Happy learning. We learning.